Senior Counsel Karua to say that me, as a brigadier to Kachungu, I called you that you are a foreigner. I have to ask you if you have that proof, and which I never did, I will apologize. And if you don't have it, I also request you apologize for saying I said you called you a foreigner. We have interacted, but it has never come out of my mouth. That is my response.
You refer to me as a foreigner.
You bring it.
And everybody remembers it has caused a lot of heat on social media.
No, bring it. But I never said so.
But there is also one issue he has mentioned. He has said that if we are not happy with the interpretation, we can go to the Constitutional Court. So I actually rise to seek to be referred to the Constitutional Court on several issues, not just on that one issue. And one of the issues is actually the jurisdiction of this court-martial. I was looking at, we have looked at the Constitution of Uganda, Article 208, which sets up the Uganda People's Defense Force, and Article 209. Nothing in those articles expressly or by implication gives the UPDF civil or criminal jurisdiction over civilians. And this General Court-Martial was created through an amendment of the UPDF Act. And it is our belief that an act of parliament which amended the UPDF Act cannot amend the Constitution of Uganda. And that the Constitution of Uganda, the basic structure, which is about how duties are divided through the three arms of government, only the judiciary has the exclusive jurisdiction on civil and criminal matters, and that UPDF can only discipline its own members. These two gentlemen are civilians. We therefore want, among other things, interpretation of that. We also want the interpretation of the fact that lawyer, what do we mean by lawyer of choice? And by arresting and sentencing Aaron Chisa when he is in court as an advocate. And the issue was a success beyond that bar, where now all these advocates are sitting. There's nothing else he wanted. He was saying, I will enter. Has that interfered with the right to representation of these two gentlemen? Is it an act that undermines the preparation of the defense of these gentlemen? We have several issues that we would like referred and which we are going to draw your attention.
The question of jurisdiction was the first thing we dealt with before I took even a plea. And the ruling of court is there. So we cannot again go backwards from where we started. So all issues are resolved. As I read to you, regarding advising on legal matters, I have given my advice. So I beg you to proceed to the chair. And make this up for Chisa, let me educate the council power. On contempt of court, you cannot say that Chisa was supposed to take a plea, he was supposed to be defended. There is nothing like that when you are in contempt of court. Contempt of court, you must understand about how it is, the whole process works. So you cannot say that the panel was not introduced by him. Those procedures don't apply.
But I think you need to cross the chapter of Chisa because he was convicted and sentenced. If you are not satisfied, you know what to do. On that one, I think let us respond.
He's still on the pan of the lawyers.
So should we adjourn up to his finishes his sentence?
The guidance we are seeking for Mr. Chairman. How do we deal with this? He
About
still has instructions.
About the convict. The one who is sentenced, who is serving the sentence.
But he still has instructions, Mr.
So which
Chairman.
means all of you cannot proceed.
I think it is very important what the judge advocate is giving us advice to this court. And I will here now declare that I've been a judicial officer of the rank of senior resident magistrate. And even in contempt proceedings, you cannot sentence an accused in their absence. You must put the contempt to them. So we are saying that procedure in this court will be very important, and it is of utmost fundamental importance, the advice given. And when we object to the advice given, it is important that the court, in accordance with the rules of procedure, pronounces itself. You are restricted to side with the judge advocate, or for good reason to differ with him, because we are objecting also based on law, so that you are given the correct procedure. What happened to Aaron Pastor happened, and he is going to take action accordingly. But if moving forward, the proper procedure is not applied, then we are at risk. That's what we are saying.